Appeals in the present case raise important questions to the 10th schedule to the Constitution of India, signature not verified, bracket hereinafter referred to as 10th schedule bracket, the election for the digitally signed by Judge Natarajan. Full stop. 11th Manipur Legislative Assembly was conducted in March 2007. The said assembly election produced an inconclusive result as none of the political parties were able to secure a majority, that is 31 seats in a legislative assembly of 60 seats in order to form the government. The Indian National Congress bracket hereinafter referred to as Congress Party bracket emerged as the single largest party with 28 seats. The Bharatiya Janata Party hereinafter referred to as BJP coming second with 21 seats. The respondent number 3 in the civil appeal arising out of SLP number 18659 of 2019 contested as a candidate nominated and set up by the Congress Party and was duly elected as such. On 12/3/2017, immediately after the declaration of the results, respondent number 3 along with various BJP members met the governor of the state of Manipur in order to stake a claim for forming a BJP-led government. On 15/3/2017, the governor invited the group led by the BJP to form the government in the state. On the same day, the chief minister sent a letter to the governor for administering oath as ministers to 8 elected MLAs, including respondent number 3. On the same day, respondent number 3 was sworn in as a minister in the BJP-led government and continues as such till date. As many as 13 applications for the disqualification of respondent number 3 were filed before the Speaker of the Manipur Legislative Assembly between April and July 2017, stating that respondent number 3 was disqualified under paragraph 21A of the 10th schedule. The present petition that was filed by the appellant in the civil appeal arising out of SLP number 18659 of 2019 was dated 31/7/2017. Since no action was taken on any of these petitions by the Speaker, 1 T.N. Howkip filed a writ petition being writ petition number 353 of 2017 before the High Court of Manipur at Impal, in which the petitioner prayed that the High Court direct the Speaker to decide his disqualification petition within a reasonable time. On 8/9/2017, the High Court stated that as the issue of whether a High Court can direct a Speaker to decide a disqualification petition within a certain time frame is pending before the bench of 5 honorable judges of the Supreme Court, the High Court cannot pass order in the matter, and the matter was ordered to be listed so as to await the outcome of the cases pending before the Supreme Court. After waiting till January, on 29/1/2018, the appellant in the civil appeal arising out of SLP number 18659 of 2019 filed writ petition number 17 of 2018 before the same High Court, asking for the following relief. Issue rule to issue an appropriate writ, order, or direction as to this honorable court may deem fit and proper. To declare that respondent number 3 has incurred disqualification for being a member of the Manipur Legislative Assembly under para 21A of the 10th schedule to the Constitution of India in terms of law laid down by the Constitution Bench of the Honorable Supreme Court in Rajendra Singh Rana and other versus Swami Prasad Maurya and others, reported in 2007 for SEC 270. If the Honorable High Court is pleased to consider that the prayer made in para number 2nd and 3rd above deserve merit for a reasonable order, a writ in the nature of quo warranto be issued, ousting respondent number 3 from the post office of minister. Para. The writ petition was taken up and heard by the High Court and disposed of by the impugned judgment dated 23/7/2019. The questions that the High Court posed before itself, which required consideration at its hand, were stated as follows: whether in the facts and circumstances of the present case the respondent number 1 can be said to have failed to discharge its duties as enjoined in the 10th schedule to the Constitution of India to decide the petitions. If the above issue is answered in the affirmative, whether the respondent number 3 has prima facie incurred disqualification. If the respondent number 3 is found to have incurred a prima facie disqualification, whether this court can issue an order disqualifying the respondent number 3 from being a member of the Manipur Legislative Assembly, or alternatively, whether this court has the power and jurisdiction to issue a writ of quo warranto declaring the holding of the post of a minister by the respondent number 3 as illegal as it being without any authority of law. In answer to a preliminary objection taken by the Speaker that judicial review is set out in cases like the present, the High Court held that the Speaker is a quasi-judicial authority who is required to take a decision within a reasonable time, such reasonable time obviously being a time which is much less than 5 years, since the life of the House was 5 years. The High Court held that the remedy provided in the 10th schedule is in essence an alternative remedy to be exhausted before approaching the High Court, and this being the case, if such alternative remedy is found to be ineffective due to deliberate inaction or indecision on the part of the Speaker, the court cannot be denied jurisdiction to issue an appropriate writ to the Speaker. Consequently, the preliminary objection was dismissed and the court went on to hear the writ petition on merits on the fact as stated above. Full stop.